Hello students, welcome back to another session of our CA Made Easy Explainer series. कैसे हो आप सब? I hope आपकी रिवीजन एकदम सॉलिड चल रही है. In our previous session, part 5, हमने बेसिक कंपनी स्ट्रक्चर्स कवर किए थे. आज हम स्टार्ट कर रहे हैं पार्ट 6 ऑफ चैप्टर 6, द कंपनीज एक्ट 2013. ये सेशन बहुत ही इन डेप्थ होने वाला है बिकॉज वी आर टैकलिंग सम वेरी स्पेशलाइज्ड, हाईली टेस्टेबल कॉन्सेप्ट्स एज पर ICI. So grab your notebooks, अपना फुल फोकस यहाँ रखो and let's get into it. फटाफट एजेंडा देख लेते हैं. फर्स्ट अ क्विक वेलकम, देन वी आर ब्रेकिंग डाउन द गवर्नमेंट कंपनी, द फॉरेन कंपनी, सेक्शन 8 कंपनीज, लाइसेंस रिवोकेशन एंड सम क्रूशियल एग्जाम टेकअवेज. लेट्स मूव.
Section 1. Welcome to Part 6, Specialized Corporate Structures.
See, you guys already know the basics of private and public companies. Now it's time to master these specialized corporate pillars for your ICAI exams. Seriously, if you logically understand these unique rules, you won't need to mug anything up. ये literally एकदम free के marks हैं exam में. Once your concepts are clear, your case studies will feel incredibly easy. So let's build that conceptual clarity right now.
Moving to our first major topic, the government company public power.
Okay, Section 2, Subsection 45. ये definition सुनने में simple लगती है. But ICAI loves to test its exact phrasing. A government company is basically a company जहां not less than 51% of the paid-up share capital is held by the government. Focus on the words not less than 51%. 50% पे काम नहीं चलेगा. It has to be a strict minimum of 51%. And who holds this? It could be purely the central government, it could be any state government, या फिर, and this is super important for real-world case studies, a combination of both. So, if the central government holds 30% and the state government of Maharashtra holds, say, 25%, combined कितना हुआ? 55%. Boom, it qualifies as a government company. Oh, and एक और golden rule. If a company is a subsidiary of a government company, वो automatically government company बन जाती है. Simple.
Look at this pie chart. I want that shaded 51% slice to be totally locked in your visual memory. Central, state, or combined, as long as that public ownership hits the 51% mark, the government is essentially behind the wheel.
Now here is where ICAI will try to set a trap for you. ध्यान से सुनना. What if a company has issued shares with differential voting rights? उस केस में, the explanation to Section 245 says that paid-up share capital should actually be read as total voting power. This is an absolutely crucial technicality. अगर डिफरेंशियल वोटिंग राइट्स एग्जिस्ट करते हैं तो आप सिर्फ शेयर्स की मनी वैल्यू कैलकुलेट नहीं करोगे. यू हैव टू चेक इफ द गवर्नमेंट होल्ड्स 51% ऑफ द टोटल वोटिंग पावर. प्लीज डोंट लेट द एग्जामिनर कैच यू ऑफ गार्ड हियर. And let's bust a very common myth right now. A lot of students think, well, the President of India holds all the shares, so the company is basically just a direct agent of the government, right? Absolutely wrong. There is a landmark case law for this, Heavy Electrical Union versus State of Bihar. The court clearly ruled that even if the entire share capital is contributed by the central government, it does not destroy the company's separate corporate character. The company is still a completely separate juristic entity. It is not an agent of the president or the central government. The concept of separate legal entity strictly applies here too.
Next up, the foreign company, the global player.
In today's global economy, this structure is super relevant. How do we classify a company as foreign under Indian law? Well, Section 242 lays down a strict dual test. Condition 1, it must be incorporated outside India. Condition 2, it must have a place of business in India and it must conduct any business activity here. Both conditions are absolutely mandatory. ये business वो खुद conduct कर सकते हैं या through an agent. For example, if it's incorporated in London but has a working branch in Mumbai, it's a foreign company. But wait, picture abhi baki hai. Let's look at the modern twist.
A law has evolved with technology. Today, a place of business does not strictly mean a brick-and-mortar physical office. A foreign company can have a physical branch or it can be present purely through an electronic mode. मतलब, अगर एक company USA में incorporated है, उसका India में कोई physical office नहीं है, but they run an e-commerce portal or have a server actively selling services to Indian customers. Guess what? They officially have a place of business in India. Electronic mode absolutely counts under the modern definition.
Okay, let's test your active understanding with a real-world scenario directly from our material. Imagine Mike Limited is incorporated in India, but it has officially set up a liaison office in Singapore. तो मुझे बताओ, is Mike Limited a foreign company under the Companies Act 2013? Apply the dual test we just discussed. And the answer is no. Did you guys get it right? See, Mike Limited is incorporated in India. तो फर्स्ट टेस्ट ही फेल हो गया.
to be a foreign company, incorporation outside India is non-negotiable. Having a liaison office in Singapore just makes it an Indian company doing business abroad. You have to apply step-by-step logic. Don't rush it.
Topic 4. Section 8 Company. Charitable objects in purpose.
These are companies that are not formed to make their owners rich. They are driven by a noble purpose. There are 3 golden rules for a Section 8 company. First, its object must be to promote things like commerce, art, science, sports, education, research, social welfare, or environmental protection. Second, it has to apply all its profits entirely towards promoting these specific objects. And third, और ये सबसे crucial point है, it strictly prohibits the payment of any dividend to its members. आप members को profits distribute कर ही नहीं सकते. Absolute prohibition. Examples of this in the real world would be FICCI, ASSOCHAM, or the National Sports Club of India.
Because these companies are doing such great social work, the central government gives them a special license with some amazing privileges. For instance, इनको अपने नाम के आगे limited या private limited लगाने की ज़रूरत नहीं होती. They can freely use words like club, chamber, or foundation. Plus, regular companies require 21 days notice for a general meeting, but a Section 8 company can call it with just a 14-day clear notice. And here's a really unique perk that examiners love. A partnership firm, which usually isn't even a separate legal entity, is fully allowed to be a member of a Section 8 company. ये points MCQs में direct आते हैं, so mark them.
Section 5. Section 8 Licenses and Revocation. Now, you know the saying, with great privileges comes strict regulations. The central government gives this license, and believe me, they can take it right back. Let's see what happens if a Section 8 company breaks the rules, acts fraudulently, or does something against the public interest. Step 1. The central government will revoke the license after giving a written notice and a fair chance to be heard. Step 2. The registrar will step in and force the company to add limited or private limited back to its name. And Step 3. If it's in the public interest, the CG can order the company to be wound up completely or amalgamated with another Section 8 company having similar objects. Matters get very serious very quickly.
And what about the financial penalty? Brace yourselves. If a company defaults in complying with Section 8 requirements, the penalty imposed directly on the company starts at a minimum of 10 lakh rupees, and it can extend all the way up to 1 crore rupees. Yes, pura 1 crore.
And what happens to the people actually running the show? The directors and every officer in default are personally liable for a fine ranging from 25,000 rupees up to 25 lakh rupees. Plus, and this is a big one, if it is proven that the company's affairs were conducted with fraudulent intent, every officer in default will also face punishment under Section 447, and we all know Section 447 is the dreaded section for corporate fraud. Long story short, you do not mess around with Section 8 rules.
Finally, our exam takeaways and wrap-up. What a packed session! We've covered 3 completely distinct structures today. For government companies, just lock in that 51% paid-up capital rule and the differential voting rights trick. For foreign companies, remember the dual test, foreign corporation plus an Indian presence, even if it's purely electronic. And for Section 8, internalize that absolute ban on dividends and those heavy revocation penalties. Before we sign off, I want to leave you with a quick hypothetical scenario. अगर एक Section 8 company अपना ultimate rule तोड़कर secretly अपने members को dividend declare कर देती है, what exact penalties will apply to the company and its directors? अभी हमने numbers discuss किए हैं. Let's see your recall power. Drop your answers in the comments below. Let's see who gets the exact figures right. Keep revising, stay focused, and I will see you guys in part 7 of our CA Made Easy Explainer series.